Hi, my name is Alexandra Wood, and I'm a fellow at the Berkman Center. I'm a lawyer, and I work on the legal and policy aspects of this project. So to start, what is privacy? Alan Weston, a Columbia Law professor, said that it's the claim of individuals, groups, or institutions to determine for themselves when, how, and to what extent information about them is communicated to others. There is a patchwork of constitutional provisions, tort laws, federal and state statutes, regulations, agency interpretations and guidance of these laws and regulations, judicial opinions that interpret these laws, and contracts that apply to the handling of data sets. And in combination, all of these things restrict disclosures of identifiable or sensitive information about individuals and data. What we're trying to do in this project is develop improved conceptions, definitions, and measures of privacy and utility that bridge the legal and technical approaches to privacy, and develop finely tailored tools to complement these new technical approaches to sharing research data in ways that preserve the privacy of human subjects. And on our team, we have Professor Urs Gasser, who is a professor at the law school and the executive director of the Berkman Center, David O'Brien, who's the senior researcher, and we have 4 interns this summer who are helping us with the legal work. And Salil introduced this graphic earlier. These are all the different parts of the project and how they interact within the Harvard Dataverse, and we contribute to 4 parts of this project. We contribute to the development of the DataTags generator. We work on policy proposals and best practices. We're developing a database of privacy laws and regulations, and we're developing custom and machine actionable terms of use. As mentioned, we're developing this database. We're writing legal memos. We are doing policy research, we're developing data tags, we're developing custom data sharing licenses, and we are working on bridging the gap between legal and technical definitions of privacy. So we are producing a database of privacy laws and scholarship. We're cataloging federal and state privacy laws and regulations concerning information privacy. We're looking at the types of information and the entities covered, the definitions of privacy that are used, the harms that are being sought to prevent, the enforcement mechanisms used. We're also looking at scholarship around privacy, and we've written about 50 summaries of these articles, and this all exists in a Google Drive that is used throughout the Berkman Center and by members of our project. And by the end of the project, we'll be making all of this information publicly available. We're also having students write legal memos. So these analyze privacy laws and how they apply in the research context. They look at how does the law restrict how data can be shared, and who does it apply to, what types of data does it apply to, and what are the various exceptions that allow data to be shared, such as the data can be shared if the data have been de-identified to some standard, and we look at what that standard is. So far we've looked at human subjects protection laws like the Common Rule. We looked at health records privacy laws like HIPAA privacy and security rules and the substance abuse confidentiality regulations that predated HIPAA. We're also looking at education records privacy laws like FERPA and the Protection of People Rights Amendment. And we've also looked at government records privacy laws like CIPSI, Privacy Act, Title 13, which regulates the Census Bureau. CIPSI, by the way, is the Confidential Information Protection and Statistical Efficiency Act, and it regulates statistical agencies that collect information for statistical purposes. We're also engaged in policy research. Last year, we submitted comments to 3 agencies. One set of comments looked at a proposal by the Occupational Safety and Health Administration to begin releasing workplace injury records available to the public. And the other two, our comments spoke more generally about big data and privacy. And based on these comments last year, we submitted a proposal to UC Berkeley, and they invited us to participate in their symposium last month on open data and privacy, security, and civil rights challenges of opening up access to government records. And through this work, we've been building on our prior work from the OSHA and OSTP comments to develop a new framework for analyzing privacy in open government data. In our paper, we looked at 4 different use cases of government releases of data. We looked at government releases of data in response to Freedom of Information requests. We looked at releases by statistical agencies. We looked at traditional public and vital records. And we looked at some of these new open data initiatives that are being rolled out at the federal, state, and local levels. And we made some observations about those use cases and the practices that governments currently use to share data. We found that most agencies, regardless of what laws apply, they almost always address privacy simply by withholding or redacting records that contain certain pieces of information that are considered to be directly or indirectly identifying. We also found that agencies lack formal guidance on privacy protection, in contrast to areas like security, where documentation is very thorough. Documentation on privacy is severely lacking, and a lot of agencies say they don't know how to identify information that's personally identifiable. We also found that similar privacy risks, or in some cases even identical data sets, are treated differently by different government actors. So we saw in the OSHA example that the Bureau of Labor Statistics, if it collects information from OSHA, they can only release summary data, but OSHA can release individual level records to the public because they are not bound by the Confidential Information Protection and Statistical Efficiency Act. And so we argue in this paper that based on these observations, a more formal approach to privacy is needed, and more guidance is needed so that agencies can analyze privacy risks in a more systematic fashion. So our framework recommends that agencies identify privacy vulnerabilities and threats, identify the information uses and evaluate the utility of the data, and align use, vulnerability, and threats with privacy controls at each stage of the information lifecycle. So the idea here is just to show how we are bringing together some of the different parts of the project and trying to make some of these ideas publicly accessible. We're also involved in the development of the DataTags prototype tool. And the way that we are integrating some of our legal research into the development of this tool is we are generating categories based on regulatory classifications of data. FERPA, for example, we've classified as having 6 different categories of ways that information can be shared from schools with other entities. So data can be shared because it's directory information, names and addresses, and other pieces of information that are identifying but not considered to be harmful. We have de-identified information that direct and indirect identifiers have been removed from the data, so it can be shared widely. And then there are a few exceptions under which data can be shared that's identifiable and potentially sensitive. They can be shared with consent, or it can be used for research studies under very specific circumstances. And then we've been generating questionnaires for the DataTags tool. And so what these questionnaires do is they ask a series of questions to determine which regulatory classification applies. So which of these 6 classifications, for example, would apply. And then we assign a data tag to the data set, and we also collect some properties about the data, and we also generate some license terms that apply to the data set. We'll be talking more about this process in the next presentation. The most difficult piece of this so far has been going from the regulatory classification to the data tag. And some of the challenges that we faced in doing this have led us to explore a more formal framework for the data tags process. And the idea here is to have a data tag represent the permitted and denied actions that can be taken with respect to a data set. And so we're formalizing the requirements of different laws as necessary and sufficient conditions on sharing data. And then based on which actions are permitted or denied on a given data set, you are able to determine which data tag should be assigned. So we're working closely with Micah Altman and Steve Chong to develop this formal framework. We're also analyzing data use agreements. We're collecting and cataloging data use agreements, terms of services, and policies from data repositories, academic institutions, government agencies, and businesses to better understand what common practices are for sharing data under a contract. We're clustering the license terms from these contracts into various categories within these different elements like data ownership, various conditions on sharing and use, the assignment of liability, various enforcement mechanisms, de-identification standards, and security requirements. And based on this analysis, we're drafting modules of license terms for the different classifications of data that we've identified. So for the different types of records under HIPAA, we are developing a set of license terms that seem to be a common practice for sharing those types of information. We're doing that for each of these different laws. And the goal is to deploy a license generator that works in tandem with the DataTags tool so that a custom license agreement can be generated for each data set. But there's no standard way of going about this. We have to look at the contracts that are currently being used and infer what common practice is based on what we've seen in the field. And we'd also like to use this formal framework as a way of assigning license terms to different data sets and determining what is the best way to generate a license for data that may contain information covered by different laws. So how do you develop one license that can handle different types of data and make sure that there are no conflicts within the license terms? So Steve's work is very helpful with solving those types of problems. We're also doing some work related to definitions of privacy from fields of law and mathematics. We're conducting a literature review on de-identification standards from regulations and from guidance on interpreting those regulations. We're writing an educational document that describes privacy and why privacy is important, what the various de-identification standards are, and what some of the tools that are available can offer in terms of de-identification, what some of their strengths and weaknesses are. And we're also working on a description of differential privacy that is accessible to a lay person. And ultimately, we'd like to draft an article on differential privacy in the law that compares the different definitions of privacy from the law and from differential privacy. And this will involve modeling the implicit threats that we found within laws like FERPA and HIPAA. They make a number of assumptions about the type of adversary that may be trying to learn something from the data. And so if we are able to better understand and model the assumptions that the law is making, we think that we can show that differential privacy can satisfy the legal standard. So this summer, what we hope to do is analyze a new set of laws and definitions. We're looking at state-level privacy laws for the first time. We're starting with Massachusetts and New York, which have comprehensive data protection laws. And we're also looking at the White House's Consumer Privacy Bill of Rights to see what types of definitions of privacy and de-identification the administration is considering. We would also like to refine this formal framework for data tags by testing the application of the framework to additional laws. We've developed this framework for just one law, and we'd like to see if it holds up if we try to apply it to additional laws like FERPA, HIPAA, and the Common Rule. We'll also be incorporating license terms into the formal framework so we can start to see how well this system could assign different license terms to a data set that are pulled from different laws. And we'll also be trying to take some of the legal memos and the annotated questionnaires that we've been developing for data tags and prepare them for publication. We think that a lot of the research that we've been doing in this project would be useful to the public. And so one way of doing this would be to develop a series of use cases. For example, looking at how the law would apply to new categories of data like MOOC data, massive open online course data. How does FERPA apply to those types of data? And we could write a paper that analyzes these use cases and identifies some of the common approaches to privacy protection under these laws and some of the gaps and barriers in these regulatory practices and practices that are in common use. Does anyone have any questions? I was hoping to use any additional time for the data tags presentation, which is going to run over, I think.
We can run, I think we can check that we can run the schedule more than 15 minutes. So we have between you and Michael still.
Okay.
Go back to the
Which one?
starting there. No, the plan for the summer. Questions? So how are you doing the? Are you switching now, or?
Yeah,
what?
switching.
Oh, we're switching? Okay, we're switching. Of course we're switching. What
You can still sit there.
Okay. Right, so, do I need like... Oh, I have enough, there's enough microphones for everybody. Oh. Okay, so we want to talk about data tags. Once I get this working. So, as we all know, it's very useful. I mean, in order to make good science, we need to share data. This is one thing that James referred to, with the whole idea of Dataverse, basically, and why we need it. But the thing with sharing data, and this is clear. I'm basically not telling you anything new. Except that the people are actually trying, some funding agencies are now really requiring this. But it's just, even if they didn't require it, would be a practice for good science to basically share your data and allow people to replicate your studies and validate what you've done. But, let's go to the, it's not that easy once you talk about data that's sensitive. Okay, so privacy issues are one thing, but there are some other cases where you don't want to share the data. Endangered species, for example. Data about polar bears. We had this issue with Dataset about polar bears where people didn't want poachers to come and get the cubs. So it's mostly about humans. And human and polar bears needs to be protected. So the question, and stars, of course, the privacy of the. So the question is how to do this, right? And once you even realize how to do this, how can we do this at scale? How can we have computers do this for us, and how can we infer things about how data can be shared? And this actually requires three different specialities. There's the legal speciality of what the law says. There's the technical speciality of what can be done. For example, differential privacy, encryption, things like that. And then there's the just knowing what we're talking about. I mean, where the data set came from. Was this a covered entity or some educational institute, or what are the small minute details of the case, which would mean, which would imply what are the legal terms that apply here. So DataTags is supposed to automate that, basically. Now, what researchers can do is either restrict access normally, or share some de-identified version of the data set to the extent that the identification is at all possible. That's another question that's being asked, or just not share at all. Okay, and we want people to share as much as they can, but not more than that, right? So the idea was just to provide a tool that generates a policy for your sensitive data, and do it in a nice, non-intimidating way. For researchers who are not an expert on legal or technological issues. Okay, so DataTags, we've seen this before. I think at the end of the day, people should be able to draw this by heart, right? We'll send out blank pages and pens. So DataTags is somewhere in the middle of this data life cycle here. And it basically is the point where machine actionable conclusions, if you will, about the data are generated. And this gets fed to various tools that can consume it and create things like risk assessment, parameters for differential privacy algorithms, and customized machine actionable terms of use, and also the actual policy of handling data, which basically means we expect Dataverse to get this set of generated tags and then act on it. Basically realize it needs to encrypt the data. It cannot send data to anyone who wants it, but it needs some verification before that verification of, for example, requiring the user to log in or to provide some proof that they are indeed the users that were approved. So this is where the DataTags system sits in the process. Okay, so we've talked about the various worlds of expertise that needs to take place in order for this system to actually work. There's a lot of people involved from different places. Do you want to expand on? No? Okay.
Last year's interns, some of last year's interns are out there, so
yes.
soon you will be a bubble in that.
Yeah, we need to make more. We need a bigger slide now.
Please.
Okay, so this work is based on pre-existing work from Latanya Sweeney. It's actually in the data privacy lab above, I think directly above us actually. And she took a survey of all the laws in the federal and state level and ended up with about 2,187 laws in the federal and state level, if I remember correctly. And basically grouped them into about 30 groups, 30 general classifications. We had the security levels from Harvard, which is it's basically an internal Harvard policy document, but it was published. So it's publicly available. It took the data, basically divided data to 5 types, depending on how harmful the data are. And it's important distinction when you say data is harmful. There's a question of harmful to who, right? So this classification just says harmful. Okay, maybe the data subjects won't be harmed, but the institution will. Okay, for example, if you breach some law, I think FERPA has you don't get federal funding anymore for a year or something like that, right? I think they have some. Anyway, so the question is what is the biggest harm that can be caused to any party, not just the data subject. And based on that, we have our data tags goals. Data tags, and we'll get to them later, but let's look at the design goals. Okay, so we want to create formal description for dataset handling policies. And by formal, I mean the mathematical version of formal, in a sense. So it's something that machine can act on, and we can do some, maybe some kind of mathematical definition based on them. But we also wanted it to be human readable. Okay, basically human readable and machine actionable together. We wanted to automate the user-friendly interview, so no need for someone from our project come and kind of guide the researcher through the process. It's something that the researcher should be able to do on their own. We want to generate the final report. These are the tags we're talking about, which are machine actionable tags and related documentation for them. So, for example, if you want to, if you claim that you took data from users and there was some consent, for example, you passed a consent form, we'll probably want the system to store the consent form so you can prove that it was indeed a proper consent. And then we wanted to interoperate with data repositories in general. We plan to implement this supporting Dataverse, but it's going to be an open standard, obviously, or at least some open, well-documented API that would allow other repositories to implement that as well if they wish. Okay, so this is basically where we affect the project. We've seen that before.
Yeah, and this shows how the different things that we're doing, like the database of privacy laws, are being integrated within this tool.
Okay, so first of all, this is a work in progress, very much like Zelig. We have our ideas. They are mostly the same, but we're some things are still to be decided. Want to talk about
yeah, so we're integrating some of our legal research into this project. So we have students writing memos in which we're trying to better understand what some of the challenges to data sharing are, what are the current flows of information, who are the parties involved, the regulatory framework, and the common institutional and contractual approaches in addition to the regulatory provisions. And we're trying to identify from all of the regulations and contracts we found, we're trying to identify typologies of common practice. How do you group together common approaches to sharing data under certain sets of terms? And we're trying to identify what some of the common practices are in different disciplines or different industries, so that we can develop a tool that is broadly applicable. So far, we've looked at 3 general categories of laws. We've looked at medical records laws, and student records laws, and government records laws. And we've started looking at contracts for sharing data within each of these 3 domains to identify the common practices. And based on this legal research, we've been developing questionnaires. So these questionnaires ask someone who's going to deposit data in Dataverse things about what's in the data, so we can determine how identifiable and sensitive the information is and what laws might apply, as well as who collected the data, which institutions may have been involved, because all of these things have legal implications. We also ask questions about whether the person who's depositing the data received the data under the terms of an agreement, and we'd like to carry those terms forward. And we, based on the information we elicit through the questionnaire, we apply inference rules to determine which laws apply and which restrictions apply to the data, so that we can determine which tag should be assigned. And we are implementing and refining this over time. So far we have a prototype that's on DataTags.org, but we are continuously refining it. As mentioned, there are these 3 steps in the process where the questionnaire lists the properties, the inference rules determine which laws apply, and therefore which handling tag should be assigned, and then we generate these simple iconic labels that indicate how the data can be stored, transmitted, or used. And this is tailored to the specific properties and the laws that apply to a given data set. And there are currently 6 levels of tags. These are the high-level iconic tags that would be assigned to a data set, and these are based off of the Harvard Research Data Policy. The first level describes non-confidential information that can be stored and shared freely without restriction. The next level covers potentially identifiable but not harmful personal information shared with some access control. And these become subtly more restrictive, and the final tag, the crimson tag, requires explicit permission for each transaction involving the data, and the parties must use strong verification, and the recipients must go through some sort of approval process and sign an agreement before accessing the data. I'll hand it off to you.
Oh, thank you. Okay, so this is one way of looking at dataset handling policies. So if you think about all the policies that can be, describe them in some, you can basically think of some sort of a soup or chowder. Right? I mean, and they all flow there, and you need to think about how to arrange them, how to specify. I want this policy where you want the data to be encrypted on transit, but not necessarily on disk, for example, or one of those. There's many small varieties and many options. So one way of making sense of a chowder is basically putting a coordinate system. Right? So you can describe it using coordinates. And the tags that we have, let's look at two types of tags, right? One describes the thing that how data can be published, right? Either with no restriction, or you need to notify the data author or the data owner, or have to pre-approve, or data are prohibited. You cannot publish, you don't make another publication based on the data. And there's the storage as well. Okay, so these are two types of coordinates, if you will, that you can look at. And each dimension, okay, these are basically 2D example, right? And each point in this table is basically a policy, right? That tells you how you need to store data and what's the publication policy. So we have a lot of tags currently. We don't have the list, but there are a lot of tags and there's a lot of dimensions. We can basically try to model systems based on these dimensions. And this allows us not to deal with just handling, but also assertions about what harms are and what it gives us basically a pretty rich metadata about the data set, which would allow us to create custom agreements and license user and determine the legal status of the data set. There's the code tag, that's the colors that we've seen before, and this gives you at a glance kind of like, okay, how restrictive the data is. And again, the tags are created based on the legal research that's being done in Berkman. Now, to actually have this system working, we created we basically have a programming language there that decides on we can define the tags. This is just the basic set of code, but you can see basically visualize them, because as I said, there's a lot of them. This is actually the most current version. There are a lot of tags. There, for example, on the handling, we have a storage, transit, authentication, auth. There's a reason it's there, but not now. And so storage is, for example, one of clear, encrypt, or double encryption. For example, authentication is either none, email, OAuth, or password. And there are a lot of them, and this is how they look like. DOA, for example, data use agreement, consists of auditing, if we need to do use, publication, etc., etc. Okay, so this is kind of hierarchical structure to it, and these are the possibilities for a tag. So a DOA the DOA tag consists of many smaller tags, and each of them can have various values. For example, use can be either research through IRB, no product, or no restriction. So these are the tags, and we need to actually select them, right? And there are two ways of doing this, or actually there are more than two ways, but there are two classic approaches. One is using some kind of logic inference, which makes sense, and there's an active effort with Steve Chong to actually model this using a language called Prolog, which is a programming language for logical inferences. We took another approach that's based on a questionnaire, basically a decision graph where we ask the user questions, and based on that we set our tags manually. So it's not as shiny and theoretically compelling as logical inference, but it's sure to work. So we're taking this sure, kind of like safe approach to deliver a product on one hand, and the correct, so to speak, theoretical approach. And we were doing this together. So the questionnaire basically needs to be developed. That's done by Alex and David.
Yeah, as mentioned, we're identifying the regulatory and contractual requirements that seem most relevant to the sharing of research data. We're clustering the regulatory requirements and the common practices into general categories. And then we're drafting annotated DataTags questionnaires. So these questionnaires give the questions that we're asking the user, the definitions of any terms that we use in our questions, and they also are annotated to describe our rationale for why we're asking the question and any assumptions we've made about what the standard is in any given law. And we are also supporting the implementation of this tool. And so the questionnaires, like I said, have the question, the defined terms. You have examples of information that would fall within a definition. We have citations to and excerpts of legal authority. We have various interpretations of the law from case law, agency policies and guidance, and policies from 30 different academic institutions. And we recommend a tag based on the answers that are given. And we have a description of how that tag should be interpreted. And we have a rationale for why a question is included and written the way that it is, and how it translates and reconciles different interpretations of the law. So here's an example question. So we want to ask a question to determine whether FERPA applies. And FERPA says that it applies to education records, which is not as straightforward as you might think. We have to ask whether the data contain any information derived from institutional records directly related to a student. And we explain that this refers to records maintained by an educational agency or institution, or by a person on behalf of the agency or institution for each student in the normal course of business. And then we say, for the purposes of this questionnaire, information may satisfy this definition even if it has been de-identified. And we say this so that we can address a de-identification standard in a later question. And so we give some examples, and these examples are pulled directly from the policies of the 30 different educational institutions that we looked at. So we have examples of what's considered to be an education record, so name, address, demographic information such as gender, race, ethnicity, photographs used for identification, current academic status, class schedule, courses taken, academic evaluations. And then we have another list of records that are not directly related to a student. So these are records held in the sole possession of the teacher, records that relate to employment, or medical records, et cetera. And so we decided to give this much detail for each question as a result of our usability testing. So we had a number of researchers who handle sensitive data test our questionnaire, and what we found is they much preferred longer questions that provide very detailed definitions and examples. And in almost every single question, they said that I need more detail to be able to answer this question. And so this is what we're trying to do, is provide a sufficient level of detail that someone would need to make a judgment about whether their data contain any of these types of information. You want to talk about this?
Yep. So here's a questionnaire. So as I said, questionnaire is this is basically a form of interactive computation, right? Where the system asks the user a question, and then based on this decide where to go next and whether to set a few tags. Or in some cases just those are the red hexagons. Just decide that we can't touch this data. Okay, this is actually an interesting case in this interdisciplinary project. Initially, the first law we had and the first questionnaire we had was about HIPAA, and it was developed by Latanya Sweeney, she's a computer scientist, but at heart she's an engineer. So basically, as things became more private and more harmful, she basically threw more encryption into it. And then we started working with Berkman, and I think it was FAIRPA, or one of those laws. And at some point, the lawyers said, "No, you can't even touch this data. It's not. You can't not even in its encrypted form. You'd be breaching. I mean, it's one of those cases where you actually took data about pupils without asking their parents' consent or something like that. Right? That would be bad. So we had to add this kind of, we can also say, no, we're not touching it. That's a whole new possibility that we weren't aware of as computer scientists. So this is, what you're looking at is the bird's eye view of a questionnaire. You're a computer scientist would recognize that this is a sort of a DAG, a directed acyclic graph, and there's a lot of work, obviously, from graph theory to be done about this type of structures. We can think of all kinds of refactorings, optimizations, things like that can happen to it. We are doing some part of it, some small things we do, like making sure that tags are being set, for example, and in all paths and things like that. But it's an interesting. There's some interesting challenges just in the graph theory part of it. So you start. It's hard to see. Right? It's obviously a big graph, but you start at the rightmost, the top rightmost oval, and you take it from there. It can also be thought of as a board game for legally interested families. Anyway, this is how it looks like. If we take a look at the one part, this is the PPRA. You can see we have questions, and based on the answers, we set different values to the tags, and we can and we move to the next node as we go.
So the purple are questions and the green is setting tags.
Yeah,
right?
yeah. And then the reds are rejections, and there's also blue ones which are calls, basically jumping in the graph to different. It's basically function call.
Question.
Yep.
This may be somewhat outside the scope, but is there any insurance against the questionnaire answerer either answering maliciously or answering wrong because they don't know the right answer and something getting inappropriately tagged?
We want to shift liability to the user.
Or that's the lawyer
No,
right there.
Right. Well, there's so this is one thing. Of course, if somebody is giving maliciously the wrong answers, you can't do anything.
Right.
But if someone doesn't know the answer, and this actually takes us back to the whole space issue. So this is actually happened to me. If you don't know the answer, most questions here are yes/no questions. It doesn't have to be this way, but it just happened this way. And this means you can actually, you can do a full, you can say, okay, I'm assuming yes, seeing what happens. I'm assuming no, and see what happens. And I take the most restrictive answer. And this way you don't know what the tags are, but you can bound them. Okay? And this actually happened to me here with Christine. Anyway, she works with health data, and she wanted to know whether she can take the data home on a weekend.
Yeah.
And this is Friday afternoon, and she can't contact anybody, obviously. Right. So we're just sitting there in the hall, and we're using the app. And at some point, she wasn't sure about something. We just assumed yes, and then we went back to the question she didn't know, assumed no, and realized these are both criminal harms. Whatever she does, she can't take it home, or she risks. So this is actually saved a researcher from yeah. So last year, the things we did last year. No, Cameron, that's for you. The DataTags tagging server API working with Dataverse. This is basically Dataverse is the data repository system. DataTags has a tagging server product, which is like the front end for tagging through a website. Okay, and they have to talk to each other and basically move. Dataverse has to basically request or refer the user to the tagging server, and then the tagging server decides on the tags based on the interview and sends Dataverse the result. So this is the protocol of doing this. Don't want to get into the minute details, but the important thing here is the thing that the error that's not there, which is the user doesn't get to tell Dataverse what the tags are. Okay, the tags come to Dataverse from the tagging server, which is a known and trusted entity, and so this helps us avoid malicious tag submission, basically, or just plain user being confused about bringing the wrong tags into the system. So that's one of the RU projects last year. That's yours.
So last summer we had interns draft legal memoranda looking at various privacy statutes, regulations, case law, agency interpretations of laws. We had them look at definitions of personally identifiable information and examples of sensitive information from different laws and regulations. They also analyzed IRB and university data classification policies from different universities, and also looked at common contractual approaches to data sharing. This is how we involve our interns over the summer. Okay, and so we can give you a demo of the tool, because this is at DataTags.org.
So this is basically what we just said. Show them the animations. No.
So we have a scenario here for the demo. So we have a data set that was collected in a 10-year longitudinal health and education study. The research was conducted by academic researchers and funded by their university and a private foundation. However, there was no government funding involved. The PI is now tagging the data set as part of the Dataverse deposit process. The subjects in the data were public school students in grades 6 through 12. Their parents received notice of the study and provided written consent for their children's participation. And the data set contains grades collected pursuant to transcript requests to the school, and the parents authorized these requests. Responses to questionnaires that were distributed to the students at the school. Some of the questions in the questionnaires cover sensitive topics such as alcohol and drug use. It also includes some biomedical data such as blood pressure, heart rate, and it includes direct identifiers such as names. It does not include direct identifiers such as names and addresses, but it does include indirect identifiers like gender, race, height, weight, and zip code. And the researchers are sharing the data under a contract that allows Dataverse to retain the data indefinitely and restricts who will be allowed to access it through the repository. So because this is a data set from a 10-year-old study, the data likely concern living persons. The data do contain some medical related information because it contains blood pressure and heart rate, among other health related data points. And then no, the data do not contain information related to substance abuse diagnosis, referral, or treatment. And although the data contains some health-related information, They were collected directly by the researchers, and it was not collected from a covered entity like a hospital or a doctor. And yes, the information was collected from students in an elementary school or secondary school, like a high school. And yes, the data concern some of these sensitive categories of information because it includes alcohol and drug use information. And although the data do not contain direct identifiers, they contain some indirect identifiers. The study did not receive federal funding from the Department of Education. Data were not collected for a purpose of marketing or sale, no. The school itself does receive funding from the Department of Education. And notice was provided to the parents. And the data contain information from transcripts that were maintained by the school. And the data contains some information from student records held by the school, yes. And the data contains some personally identifiable information about a student because it contains some indirect identifiers like gender, race, ethnicity. The information that was collected was not designated by the school as directory information, which is limited to names, addresses, etc. And yes, the parents gave consent. The study did not receive federal funds. This data were not collected from a DMV. The data are being shared under a contract that allows Dataverse to retain the information indefinitely. And yes, there are some restrictions on sharing. And eventually that will lead into an additional questionnaire about what those restrictions are.
And now we can see that the big tags.
Yeah, so this tells you some things about the data. We know that it's an orange data set, meaning it contains sensitive, identifiable personal information that can be shared with verified or approved recipients under agreement. And we can also see that the information is covered by FERPA and the Protection of People Rights Amendment. Access to and use of the information is restricted, and the data must be stored and transmitted using encryption. And these tags will eventually be used to generate custom license agreements that will give more specific information about how the data can be handled over time. And you can, if you hover over, you can see what these tags mean. So this means that the data contain identifiable information from education records disclosed with the consent of the parents or eligible students. Yes?
The data itself doesn't have a tag, like the color, like SAT score is not identified as a orange or green. A series of questions, after you answer the series of questions, then the data itself becomes some kind of color. That's where the color.
Right, so the tag is assigned to a data set, not to an individual piece of data.
Mm-hmm.
Maybe more kind of question about the coordinates in the data storage, but is the planning of this modular at all, like to Mars education data are way more private, or way less private than we think of it today, how easy or difficult or impossible is it to adjust data tags accordingly?
So, first of all, changing the coordinate systems or changing the tags is very simple. From a technical perspective, it's just, as you say, it's a program. You just add a line. The question is how this affects existing policies, right? So either, if it's basically, the legal team can see if this works, if you can make assumptions from the current tags to using the new system. And if not, at least you know that which data sets needs to be retagged. I mean, we have the answer history, right? And if we actually retain that, we can basically rerun the questionnaire if there are no new questions. So there's a lot of wiggle room for us, and hopefully we can. It depends on the change, really.
Alexandra, and you mentioned earlier, I think in your earlier presentation, the work or you're doing with Micah and Steve, maybe to kind of abstract the way in which you come up with the tags in the surveys, right? So the idea of that is to make it possible for someone else to go and recreate a survey and a set of tags if a new law comes about, if I understand correctly. Is that right?
That's right.
So we don't expect in the course of this project to handle all laws and regulations that are relevant to privacy, and so the idea is to have build things and document things in a way that other people can continue this work and extend it. And the same also goes for the differential privacy work that you'll hear about tomorrow. We don't expect in this project to implement and make practical all the possible things that one might want to do with differential privacy for analyzing data sets. We'll get a small piece of it as a proof of concept, and that hopefully is something that's useful already, but try to build a system that then later people can add more pieces to it. I mean, the research community at large.
Mm-hmm.
Other questions? So I have one more question. Is it new? So this one survey asked both about health and education. So is that a recent development, the sort of integration of the surveys from the different things, or has that been there for a while?
That's been there for a while.
For a while, yeah. It also asks about driver's licenses, right? The DV, something with D.
There's a law that applies to DMV records.
Oh.
All right, so I know it's been a long day. Actually, last year I think we packed it even more. So we tried to spread things out a bit. So that's all for today. Feel free to, after we break, to ask more questions. I'll be here for a bit if you have any questions. And then the plan for tomorrow, just to recap, in the morning we're going to continue with sort of project-wide overviews, and Michael Altman at 10:45 and is kind of going to give a piece of the course, kind of the intro. He teaches a course for social scientists managing confidential data, and he's going to kind of give the beginning of that course as to sort of another type of sort of overview of the handling of data. And then, am I after that?
Yep, you're after.
I will give a non-technical overview of what differential private. You've probably heard this buzzword several times today. You may be starting to wonder what it is, so your suspense won't be there for that much longer. And then in the afternoon, we'll sort of start to get more technical for those who are interested or working on things related to differential privacy, R, programming, timing for tomorrow morning, when we start?
So our youth students are on at 10:30, so we start at 10:45. I will meet you in the lobby at that.
Any general questions?
I will be taping it myself, so it'll be a little bit lower quality, but it'll still be taped.
All right. Thanks, Michael and Alex.